respected colleagues in legal profession, learned members of the bar, my friends and fellow citizens, today I wish to address an issue of immense constitutional importance, the relationship between liberty, judicial discipline and public faith in the judiciary under the framework of Unlawful Activity Prevention Act, popularly known as UAPA Act and other anti-terror laws. My friends, recently on 18th May, the Honorable Supreme Court in Sr.Advocate Andrabi versus National Investigating Agency delivered a landmark judgment reaffirming a fundamental constitutional principle that the personal liberty and speedy trial cannot be subordinated to the statutory restrictions contained in Section 43D, Subclass 5 of Unlawful Activities Prevention Act. Honorable Justice Ujjal Bhayan and Justice B.V. Nagaratna rightly observed that bail is the rule and jail is the exception. It is not merely a statutory concept, but a constitutional principle flowing from the Article 21 and 22 and from the presumption of innocence. This is deeply important constitutional reaffirmation. My friends, in recent years, we have increasingly witnessed situations where prolonged incarceration itself becomes punishment before trial. The process becomes the punishment. The court rightly clarified that Section 43D subclass 5 cannot override constitutional guarantees. Statutory restrictions must operate within the constitutional boundaries. The bench also emphasized another vital principle, judicial discipline. The court observed that the earlier two-judge bench decision in Gurvinder Singh versus State of Punjab and Gulfisha Fatima bail judgment had diluted the ratio laid down by the binding three-judge bench judgment in Union of India versus K.A. Najib. The Supreme Court correctly stated that smaller benches cannot overlook or depart from the larger bench decisions. If disagreement exists, the constitutional court is reference to a larger bench. This principle safeguards consistency and credibility in constitutional adjudication. Then what makes this issue more concerning is, my friends, is that what followed immediately thereafter, after this Andrabi judgment. On the very next day, the learned additional Solicitor General reportedly argued before another bench that under UAPA, the presumption of innocence takes a backseat. But Andrabi judgment itself rejects such a constitutional approach. Presumption of innocence is not a technicality, my friends. It is the foundation of civilized justice. Even more concerning is that despite this important judgment, interim bail was reportedly denied to Umar Khalid soon thereafter. And the bench before which Additional Solicitor General argued, my friends, on May 2022, this bench granted bail to two accused in 2020 Delhi riots case, Abdul Khalid Saifi and Taslim Ahmad, and also referred to a larger bench. The question of whether a prolonged incarceration and delay in trial can overlook the stringent bail conditions and curbs under anti-terror laws such as UAPA Act 1967 by arguing that the Andrabi judgment has misunderstood the reaffirming the reasoning behind Gulfisha Fatima verdict. This creates a serious public concern regarding consistency in the application of constitutional principles. The issue is not about supporting any ideology or individual, my friends. The real issue is equal application of law. When society sees influential persons, notorious offenders, or even convicted individuals receiving bail, parole, or remission, while activists, students, journalists, or dissenters remain incarcerated for years without trial, people naturally begin questioning whether liberty is being applied selectively. Such perceptions are dangerous for a democracy. My friend, public confidence in the judiciary depends upon the belief that the courts are independent, impartial, and constitutionally consistent. Babasaheb Dr. B.R. Ambedkar, the father of Indian Constitution, envisioned the judiciary as an ultimate guardian of constitutional morality and fundamental rights. That constitutional responsibility becomes most important in difficult and politically sensitive cases. Fundamental rights are meant especially for unpopular persons and inconvenient voices. National security is important, my friends. Terrorism must be certainly be dealt with firmly, but constitutional democracies cannot abandon constitutional safeguards in the name of security. Otherwise, the extraordinary laws risk becoming instrument of indefinite incarceration without conclusion of trial. If a person spends years in prison and is ultimately acquitted, no judicial order can restore the lost liberty, life and dignity. That is why constitutional courts must remain vigilant guardians of liberty. The Andrabi judgment is a welcome constitutional correction, but the constitutional credibility ultimately depends upon consistent implementation of constitutional principles across all cases. Today, the higher judiciary must introspect and reaffirm through the action that liberty is not selective, that the constitutional guarantees apply equally to every citizen. The people of India still look upon the judiciary as a last constitutional refuge against arbitrariness and abuse of power. That faith must be preserved at all costs. Thank you, my friends. Jai Hind, Jai Constitution.